Hi, welcome back to La Belle Vie. So, we have an update on the Tiger Woods saga with his ex girlfriend. The court on Wednesday evening granted Tiger's motion to compel arbitration. The first finding that the court made was that there is no substantial factual issue that there is an actual agreement in place that contains an arbitration provision. So, the little fact about the Ms. Herman's lawyer saying she didn't recognize it, et cetera, that was not enough. And here they say, their attempt to say she didn't remember signing it, it doesn't create a disputed fact. You have to contain unequivocal assertions that this is not the document, and the court found that that was not the case. So that was not surprising at all. What is probably the more interesting argument that, as I mentioned, that the Ms. Herman's lawyers used to try to get out of this mandatory arbitration was to try to argue that the Forced Arbitration of Sexual Assault and Sexual Harassment Act uh, basically precluded Tiger's team's ability to put this matter into a mandatory arbitration because again, it's in Ms. Herman's best interest to have this case play out in the court of public opinion and state court. And of course, it's Tiger's best interest to have this be in confidential mandatory arbitration. So, as I mentioned in my last video, you have to show more than just saying harassment occurred. I mean, there's got to be some facts, facts sufficient that if a motion to dismiss were filed, it would survive that. And so I was when I in my last video I mentioned that I just didn't see them being able to show that there was not more there. There's got to be more there, right? Just saying something's harassment is not enough, and that is exactly what the court found here. And I think that's the right decision. I mean, the act is very important, but you also don't want to have the act used in a way to kind of, not protect what it was meant to protect. It was meant to protect individuals that want to bring claims of sexual harassment or sexual assault that they can't be forced to arbitrate those claims. But you've got to actually make a claim, a base claim of sexual harassment, and she did not. And they make the point, like, she's had the opportunity to provide factual specificity for any claim relating to sexual assault or sexual harassment, but she has not done so. And additionally, at no time did her counsel request an opportunity to file an amended complaint. That was the thing I was thinking, is like, why doesn't she just file the amended complaint? And I think the assumption is that there's nothing there. And that's, I think, one thing where, again, I'm not on either side of the case, but I think that that is something that probably was frustrating for Tiger's team because, we saw the headlines, sexual harassment, Tiger's ex-girlfriend claimed sexual harassment, which was not what was going on. It was a procedural move. It was a strategic, smart move to try to get this motion to compel, to try to get this arbitration clause held to be invalid for her. It didn't work. But in the meantime, you had the media saying, oh, she's accusing him of sexual harassment, which was not the case. And so that was actually why I did the video, because I wanted to make that clear what was actually going on. So basically, I find that, there was no facts to bring of either sexual assault or sexual harassment in order to bring this into that statute that would mandate that arbitration should not be held. So there's that argument. The third argument was that if there is, any argument as to whether the non-disclosure agreement itself is enforceable, that is a matter that if the agreement is subject to arbitration, that is something for the arbitrator to decide, not for the court. And so they again found in favor of Tiger's team on that, and apparently even at the hearing that her counsel had conceded that point. And then finally, on the last kind of throwaway claim that the team brought in was this idea that Tiger had waived his right to compel arbitration. And again, as I mentioned in my last video, I didn't see that going anywhere because at every angle, at every point of the process, we've seen Tiger file his own motion for arbitration. We've seen the trust file a motion to compel arbitration. And then, of course, this third lawsuit that Ms. Herman brought against Tiger directly, he, at his first instance, filed a motion to compel arbitration. So I did not think that there was going to be a waiver argument. And not surprisingly, the court agreed. Okay. So there we go. So this case will be now. It has been dismissed. It will be go to arbitration, and I suspect, as I mentioned in my last video, I suspect there will be a settlement. Um, it's obviously in Tiger's best interest to settle with Ms. Herman for confidentiality reasons again, and get another ironclad NDA. And to be fair, she spent, I think, more time with him than when he spent with his wife, his ex-wife. So, I think at the end of the day, it'll settle, and it'll settle in a very confidential way, which is what exactly Tiger wanted and any public figure would want. My takeaway is, again, I mentioned in my last video, this is not legal advice, but just a word to the wise. It's not usually a good idea to get involved with people that work for you. And then also, I think that something that could have been improved upon in this case is that if you're going to have a dual relationship, right? She had her working relationship with the Woods Jupiter and she had her personal relationship. If it was an NDA involving her position as an employee of the company, then the NDA should have been with the Woods Jupiter and with her as employee. And then separately, the NDA, because of her personal relationship with Tiger, that should have been an NDA with Tiger and with her. Just again, not legal advice, but I think the more that you make these relationships clear as to what you're trying to protect, that's really what's going to be critical when you get to the point where you actually want to enforce these documents, because otherwise they're not written, they're not worth the paper they're written on, right? You obviously, if you want someone to sign a confidentiality agreement, you want that to be enforceable. So thanks again for joining. I hope to see you back. I'm finishing some Markel content, which is why I was out yesterday and didn't see this. This was granted until this morning. But thanks again for joining. Please consider liking and subscribing, and I hope to see you in my next one. Bye.